Good evening. I'm Jim Twombly. Some of you probably recognize me, I hope you do, from WBNY. I want to start off by noting that in Jim's presentation, one of the things that's important, I think, is to understand, Alexander Hamilton was key in the New York State Ratifying Convention. You might also recall he was one of the three authors of the Federalist Papers. And the Federalist Papers were written to defend the ratification of the federal Constitution, but primarily to elect delegates in the state of New York favorable to that ratification. That's what the purpose of the Federalist Papers were. And then they became very, very popular and began being published as editorial or op-eds in newspapers all across the country, starting with Philadelphia. I agree with much of what Jim said, that a constitutional convention, in theory, is a wonderful little d democratic institution, and we should champion them. I think we need to put New York's process in context. We have a 20-year periodicity, along with 7 other states do that every 20 years, automatically by constitutional fiat. The state must put on the ballot a referendum to the voting public, the question whether or not they want to hold another constitutional convention. There's one state, Michigan, that does 16 years, 4 states that are every 10 years, 1 state, Hawaii, is every 9. Why 9? I don't know. Why even 16? That's kind of odd too. Others are only by a vote of a majority or supermajority of the state legislature. Some are coupled with the consent of voters in a referendum, but there's no periodicity required. 4 states use citizen-initiated petition to call for a convention, and 7 states have no specific mechanism in their constitution to call for another constitutional convention. Those 7 states are Arizona, Arkansas, Indiana, Mississippi, New Jersey, Texas, and Vermont. Oregon allows for a convention, but its constitution is somewhat vague about how one is called. Most states require that any product of a convention be put to a vote of the public in a referendum. So, yeah, there's a lot of ambiguity in state constitutions about the process, and I would agree that New York is best, one of the best at least, in terms of detailing what the process is. I would agree, I would argue that perhaps maybe 20 years is perhaps a bit too long. How many of you remember the great debate that we had in 1997 about whether or not to have a constitutional convention? 1. We don't remember 20 years back. And I think that if we're going to follow the Jeffersonian notion of every generation, maybe we need to go a little bit sooner than every 20 years. And I would argue that that probably would be a better little d democratic process to have that referendum sooner. How do we select delegates? Well, in New York, it's 15 at-large delegates elected statewide and 3 per senatorial district, state senate district. The math was what? 204, I think, was the total number. Somebody can check my math on that. 204 sounds like a nice number. But how many of you live in a state senate district that is dominated by a party not your own? 2/3 of the room. So there's a little bit of a problem politically with the process. You might end up electing 3 delegates from your state senate district, none of whom agree with you politically. And as Jim and I were discussing beforehand, I'm in one of those districts. And it is not likely that I could get elected delegate to the state constitutional convention. Yet you would think that somebody who teaches state and local government, constitutional law, American government and politics, maybe should be at a convention like that. I probably couldn't get elected. I'll have to hope that somebody appoints me to the staff. A number of states use different mechanisms for selecting. Colorado uses state senate districts. California uses equal population districts, whatever that means. Delaware has a detailed description of how delegates are chosen, including use of representative districts and some other allocation from counties. I tried reading through it over the weekend, and I fell asleep in the middle. Florida's constitution refers to selection within representative districts, unless there's a colloquialism that refers to a specific, like, lower house representative. I've sort of lost track of what they were talking about. Georgia just says population as near as practicable. Hawaii leaves the number of delegates and method of selection up to the legislature. Guess what the districts will probably be in Hawaii? Idaho, double the number of the representatives of the most numerous branch of the legislature. And that's a quote from their constitution, most numerous branch of the legislature. Illinois seems to imply that it's, the delegates are elected from the same districts as the General Assembly. Kentucky, delegates are elected with the same qualifications and from the same districts as the lower chamber of the state legislature. Maryland sets, the legislature sets the parameters for delegate selection. Michigan uses Senate districts. Minnesota is the same as the lower house. I could go on and on through this list. A couple of them. Oklahoma provides no details. North Dakota, no details. Pennsylvania, no details. One would assume that when there are no details listed in the state's constitution about how you select delegates to a convention to propose amendments to or replace the state constitution, that it's left up to the state legislature, the very body you might be seeking to reform. According to the website Ballotopedia, the constitutions themselves range from Vermont's modest constitution of about 8,419 words, about, I guess that's rather precise, to Alabama's 172,000 plus words. The average is roughly 26,000, about 4 times the size of the federal constitution. New York's is twice that size in terms of the number of words. Now, that's not to say that being larger than the federal constitution is necessarily a bad thing or an out of the ordinary thing. State constitutions tend to do more and be more specific than the federal constitution. We see the federal constitution as this broad, relatively vague document left open for interpretation. State constitutions, states generally don't want to have that kind of interpretation of the document going down the road. Plus, there is this periodic mechanism built into many states where the constitutions can be changed. So why make it vague and open to interpretation if 10 or 20 years down the road you have the opportunity to change it? So make it specific. But sometimes it's a bit too specific. 172,000 words in Alabama's state constitution. What the hell are they talking about? It's probably one of those cases where Mississippi can say, at least we're not Alabama. There's the old line about, states that fall low on various quality of life measures, like levels of education. Mississippi used to say, at least we're not Alabama. I've forgotten now who's last. New York's constitution is a bit overly complex, long, and surviving on sometimes awkwardly stuck-on amendments. Is it in need of an overhaul? Probably. But I would argue that given the current mechanism by which delegates are selected and some of the current politics that Jim alluded to, this may not be the time to do it. I don't oppose a constitutional convention. I've come around in the last year or so to think that this is not the time, especially given the process of selection. I'd be more apt to support a constitutional convention if we could first amend the process by which we elect the delegates and make that more fair. Perhaps more at large, or perhaps electing by assembly district or proportional representation of counties. some other mechanism, and I think Jim and I were discussing beforehand too, that perhaps some proportional representation, not just county to county, but within counties, so that folks would have a choice, and if you had 10 delegates from a county, and 60% of the population wanted to go in one direction, 6 of the delegates would be elected that way, and 4 would be elected another. It's a mechanism that can be worked out another time. We don't need to bore you with those details. He and I can get into a battle of PhDs later and discuss how we would do that, different mechanisms. But certainly that would be a more fair way to pick delegates to a constitutional convention to ensure that everybody's voice is heard. One of the other problems I have is that members of the state legislature are not prohibited from running for or serving as delegates to the very convention, again, that we might seek to use to reform said legislature. Talk about a conflict of interest. And think about it, as an average citizen who might want to run for delegate to the state constitutional convention, how are you going to beat your incumbent assembly member or state senator? Tough to do. State senate districts, as the basis of representation, make for rather unwieldy campaigns at the local level and would tend to lower the levels of diversity among the delegates. Plus, given the relative sizes of those districts, interest groups will play a disproportionate role in the selection of delegates. That's on both sides. And I'm not taking sides with interest groups. I prefer some interest groups over others. But I don't necessarily want to roll the dice that the ones I don't like are going to dominate the selection process in my district because of the amount of money they can contribute. Some of the current concerns. And these, I just picked out 3. I have a pamphlet over there that I downloaded where there are 106 different issues. And you could take the pro or con side on each one of those that a constitutional convention could potentially raise. These are the 3 I picked out as what I thought were the 3 hottest button issues. Control of the state pension fund and the independence of the comptroller. Now, we've seen lately that the governor has backed off on his support for a constitutional convention. Could it be that every state public employee union has said no, and that may be why? You don't want to run for president when all the public employee unions in your state don't like you because you backed the Constitutional Convention. There are those who wish, whether it's the governor or not, there are those who wish to politicize control of the pension fund. Right now the pension fund is controlled by a single person who we elect. There are those who argue that that pension fund should be directed by a politically appointed board. Another issue, hot button issue, and I see some representatives of those public employee unions in the room. Protections for workers' rights, including the right to collectively bargain. There are those who argue that while New York generally is a progressive state, and you wouldn't necessarily expect it, talk to the public employee unions in Wisconsin. Oh, we're a progressive state, that'll never happen. Consideration of a unicameral legislature. This scares the daylights out of a lot of people, but one of the possible books that Karen didn't mention is one that's based on a paper I presented a few years ago at a conference, the United States of Nebraska, the case for a unicameral legislature. Nebraska is the only one of the 50 states that uses a single chamber legislature. I think New York should at least explore that possibility, perhaps to save some money. A rough back of the envelope calculation I did a number of years ago said that the state in a single year could save $81 to $100 million in salaries alone. The biggest argument you get against that is people don't want to give up the second representative they have geographically. One of the ways you can mitigate that perhaps is to increase the size of the state assembly to give more one-on-one representation. That's just 3 hot button issues that people are concerned about. You probably all have your own little pet peeve about what a state constitutional convention could or should do. And I think it is an important little d democratic process. My fear is the fear that many others have, that because of the way we select delegates, we may be electing a state constitutional convention that could damage some of the rights and freedoms we've grown accustomed to in New York. And until we change that process, I'd be hesitant about supporting a state constitutional convention. That doesn't mean if there was one called, I might not consider running for delegate. That's all I have.
Our speakers are willing to answer questions, or try to. Diane?
You can't refer to us by our first names because that gets confusing.
For either one of you, this is about process. When the, if we pass the referendum for a constitutional convention, and then a year from now, when we vote for delegates, I would think that we would get to vote for three come from our senatorial district. Are they running on a political party? And we select three, is it away? Do we first, second choice? How does that work?
It's 3 elected district-wide currently, and there's no prohibition against partisan election of those delegates. The State Bar Association has a report which looks at the possibility perhaps of doing nonpartisan elections.
So when you think about the delegate selection, part of it's specified in the Constitution and part of it isn't. And what is in the Constitution, what isn't, varies by state. By the way, I have a website in addition to my New York Constitutional Convention Clearinghouse. I have one that covers all the state Constitutional Convention Clearinghouse, which covers all 14 states and the language and the constitutions that specify them. So it is great in New York. There are problems, but it's great that the districts are specified in the Constitution. 13 of the 14 districts actually are specified, because then you don't have the gerrymandering. They may not be ideal districts, but they're specified. It reduces the potential for legislative abuse. So that's a big deal. But the Constitution doesn't specify everything, and the issues of the partisan nature of the ballot and whatnot, all those secondary items are left to the discretion of the legislature. It will be aggressively contested, and there are ways to bypass them by creating separate slates and whatnot. And so those are real concerns. I've written several op-eds specifically on how that process should be structured. And unfortunately, the legislature will not design the optimal system.
Not for us anyway, for themselves maybe.
Yes, and I think we can do better than what's in the Constitution if we had another referendum. I'm in favor of ranked choice voting within the districts and other obscure things that you won't know what we're talking about. But yes, we can't answer a lot of these questions because the details of the campaign finance and other things are not specified in the Constitution. And if we go ahead, the legislature will have control over some of those details. So that's all. I want to make one other statement. The one that's used most often for a high percentage of legislative control is 1967. It was still only 4.9% of the delegates were state legislators who were incumbents and then ran again. That's a relatively small number. I'm not aware of a single constitutional convention in the 20th century called the Periodic Constitutional Convention Referendum that had more than 10% of incumbent state delegates in the convention. And one reason for that is it's risky for, you're running for 2 different offices and you might lose, and the public doesn't really like to vote for legislators. They typically don't. So it's by no means a sure thing, and they typically lose. And legislators don't like to lose. So actually, it's not stacked in favor in front of legislators, as you're often told. If you look at the actual numbers, they're very small.
Right, and the case that I mentioned before is if you're the unfortunate ordinary citizen who wants to run and you're running in a district where an incumbent is running, you are at a disadvantage there. simply because of name recognition and ability to raise funds. Presumably, the state legislature in the call for the convention, once the referendum passed, would lay out the specifics of the selection process, and they could say nonpartisan election. I don't think that the New York State Legislature would do that. So, yeah, that's sort of up in the air, and the process part, Jim and I can get into the weeds, and we'd be here all night, but you guys all have questions.
Can the people in the back of the room hear the questions?
Yes.
That's good. Okay, if anybody speaks softly and wants to use the microphone, please do. Okay, you're next, please.
I have another question to that topic, which is just ballot access. If you wanted to be a candidate, how was that selection?
Currently, under New York State law, I would imagine, unless the legislature changes it specifically for delegates, and we're talking about the district delegates here, the same rules as for a state senate candidate would apply. So the number of signatures you'd have to gather would be the same as a state senate candidate would. I'm not sure of the number now, it's 1,200, 1,500, somewhere in that ballpark. And Denise is looking it up for me. So you'd have to get that for each delegate running in a state senate district. They're obviously much larger numbers for the 15 at-large delegates running statewide.
You know, and it's harder, actually. It says here, for your Senate district delegates right now, if you are part of an established party, you need 1,000 signatures or 5% of the enrolled party. But if you're trying to run as an independent, this is how they do it. You need 3,000 signatures or 5%.
Yeah, and the established parties, there are 8 established parties in the state of New York.
Yeah,
Democrats, Republicans, Conservatives, Independents, Green, Working Families, Reform,
women's equality.
and Women's Equality. Those are the 8 recognized parties in the state of New York that fall under that portion of the state election law. Obviously, for the smaller parties, it's the 5% and not the 1,000, so it's a much smaller number. But that means getting in your car and driving around to these individuals to get their signatures if you want to run on their lines. Statewide, it's much more restrictive, even for the independents. It's usually double or more the number of signatures for an established party. So being an independent, not an independence party member, being an independent in the state of New York is tough if you really want to be an independent and run for public office.
Okay. Mary?
Okay, a question is, you mentioned that this is a people's initiative. Well, Citizens United totally changed the definition of what the people are, and it's including corporate. The corporations have been given the same rights as people, and so I'm very concerned about the corporations will have a say in who the delegates are selected if we were to pass this Constitution. And the two things that I'm very concerned about, so that for me is the time is wrong. Until we overturn Citizens United, the time is wrong for a constitutional convention. But the two things that really concern me the most are home rule. That home rule, New York State is one of, I think, 7 states that has home rule. Home rule is critical. We have legislation in place in different towns. It gives towns and villages the right to say no to certain things in the state. And that could be overturned. And the other thing, too, is public education. The right to a public education is much stronger in New York State than it is in the U.S. government and the federal. And we could possibly lose the right to public education, especially considering the charter school movement. They would love to see public education. So I'd like you to speak to the Citizens United part and to the, or both of you, either of you. And
Yeah, just 2 things on Citizens United. First of all, the logic there when it comes to the third vote, the ratification vote, is the same whether it's a legislature-initiated referendum or a constitutional convention-initiated referendum. So basically, you'd be arguing you should create a pause to all constitutional amendment until we get rid of special interest money in the referendum process. Second element is, where is money effective in referendums And the literature is very clear that money is most effective, far more effective if you want to kill something, rather than if you want to pass something. And so that mitigates it. People are very actually conservative on constitutional amendments. Whether the legislature or constitutional convention proposes them, a lot of them go down, even some that seem relatively innocuous. And so the major effect of money is the ability to kill something. And one reason you can't have any poison pills today in what you propose is that somebody who doesn't like something else will focus on that poison pill and spend a lot of money and kill it. So basically the effect of Citizens United in the referendum process is to make it easier to kill things. But if something is popular, it is not a vehicle for getting things passed. So it has an asymmetric effect. So I think that tempers, I would agree, that was an unfortunate Supreme Court ruling, and I believe we do have too much money and unregulated money in politics on both the business and the labor side. And labor has been also very strongly opposed to much of the transparency, just like big business on some of these issues. So yes, it's a concern, but if we follow that too closely, our democracy can't improve, because, I mean, we still have to go ahead with our democracy. But I agree, it's a concern.
Okay, the gentleman in the last row.
Well, I just
Dora?
wanted to ask you, because it just, in reference to what you just said that labor is putting a lot of money into blocking transparency. Can you explain that? In what way would they be blocking transparency?
Well, it wasn't just in general. I've been involved with the League and Common Cause and other groups over the years. When it comes to campaign finance, the way it typically works on a partisan basis is conservatives like more labor transparency, and labor fights back, and vice versa. And the argument is that there's a lot of money in politics that is not disclosed, and both sides who benefit from money have objected to greater campaign transparency. And that's primarily, I know, Washington politics best, but that's just a basic rule of thumb. If you benefit from loopholes on either side, you want to preserve those loopholes, and the major powerful interest groups have a lot of those loopholes that they benefit from, and they don't want them shut down. So it works on both sides. Basically, any powerful interest groups will prefer the status quo. They may talk as though everybody talks that they love transparency. There's no legislator on the face of the earth who's ever been against open government. It just doesn't actually happen. And the same thing with transparency and campaign. People talk that way, but when you see what's going on in the back rooms, they tend to oppose the specific legislation to make it a reality. So that's all I have to say.
Thank you. Gentleman in the back row.
Yes, you set out two forms of amendment. One is the legislative process, where the voters get to vote on a particular amendment after two successive legislations passed it. And the other is the convention process. Isn't there a missing process here, which other states have, where you can amend by a popular referendum? And wouldn't it be better in New York if we first had a singular amendment to the Constitution, allowing the populace to have a referendum on a particular issue in the Constitution, rather than risking the entire Constitution to a group of delegates, none of whom have ever done this before, have no experience whatsoever, and have a one-time chance to be brought out?
Okay. I think it's very important to talk about the popular initiative. 19 states have the constitutional initiative. New York is not one of them. So I wanted to be practical. That's not an option with the current Constitution. The only two options you have now are the legislature initiative amendment and the periodic referendum. And they are the periodic constitutional convention referendum and the popular constitutional initiative are competing institutions as legislative bypass. And I think it would be great if New York had a discussion there's lots of different types of constitutional initiatives popular, because that's a competing institution, but it just, as a practical matter, you don't have that now, and it's very, very hard to get the legislature to create such an institution. So I think that's a useful debate, but it's just, you've got to make a decision, and it's not something you have in New York. It's not a mechanism available in this state.
Yeah, I would agree. In terms of the practicality, New York only has the two routes available to it. And I would agree that that would be a healthy little d democratic debate to have. There's some caution, though, that has to be exercised. And while I generally err on the side of little d democracy, ask California how their initiative process has worked out for them. If not for Proposition 13 back in 1979, Arnold Schwarzenegger never would have been governor of California. It's the hamstringing of the state legislature with regard to raising revenue by Proposition 13 that caused the recall of the incumbent governor, Gray Davis. And Arnold Schwarzenegger became governor of California as a result. Now, everybody wants tax relief, and we can understand why California voted the way it did. And at the time, they had a very terrible real estate tax situation. And I'm not saying that we would go that far, but we just need to be careful about how much we popularize democracy. One of the things we believe in as a society generally, and this is most of the Western world, is in something called liberal democracy, and that's not liberal versus conservative. Here the term liberal goes back to Adam Smith and the notion of individual liberty, and that representative democracy was put in place to make sure that a majority couldn't run roughshod over a minority, that a majority of the people could not take away the rights of a minority of the people. In Colorado, a while back, they had a situation where a majority of the people voted for a particular gerrymandering scheme. The Supreme Court struck it down and said, no, you can't take away the rights of the minority. The same thing happened with Proposition 8 in California, a poorly worded public proposition that was designed to overturn the act of the legislature in granting same-sex marriage rights to the LGBTQ community. People who thought they were supporting those rights were voting against it. So on the basis of the poor wording and the fact that a popular referendum could not take away a right once granted, the Supreme Court said, well, actually it was the Ninth Circuit Court of Appeals, said no. Never got to the Supreme Court because of the other DOMA decisions that got there first. But we need to be careful in terms of how we would structure that. I would welcome it, especially the opportunity for recall, but we would need to be careful on how we structured that initiative so that we don't end up like California.
Just one thing on the California, if you ask Californians, however much political science, some political science